Well, good evening, everyone, and welcome back to AJ103, Criminal Evidence Online. Tonight's lecture is going to be on Chapter 5, where we will be discussing direct and circumstantial evidence. Now, as with previous chapters, I want to let you know that there's a lot of information to go through. So, again, it would be incumbent upon you to take the time to read the chapters, look at the key terms, the discussion questions, and then also go through and look at the examples that they have in each area that will help you add some greater context to a lot of the definitions and terms. And those examples, again, they're really good to help you kind of break down the terms further, and they'll give you a better understanding on those topics and those subject matters that might be a little bit confusing or technical. So our featured case tonight. In 2007, Joshua Komisarjevsky and Stephen Hayes kidnapped, raped, and killed Jennifer Petite and her two daughters. And direct and circumstantial evidence clearly proved guilt, and each was subsequently sentenced to death. Now, the defense argued that the offenders were themselves sexually abused and traumatized, thus one of the reasons for possibly the assaults. So when we look at this case, and I know you're going to read it because it's a pretty cool case, what evidence was proper to consider in determining guilt, and what additional evidence is necessary to really impose the sentence? And when you apply it to these types of brutal crimes, and this certainly was one of those, crimes like this are a shock to the common sensibilities of most people. And so when is it appropriate to allow the jury's emotions to play a greater role? And should we use emotions to allow greater sympathy for victims, thereby thereby harsher penalties for offenders? And finally, should sympathetic offenders get lighter sentences? And these are all questions that we kind of have to ask ourselves. I also included in here a case study on corpus delicti. And if you want to know a little bit more about corpus delicti, you can Google the term. We'll talk about it later in some chapters coming up. But this is an interesting case where, well, I don't want to give it away. So just watch the case and you'll understand kind of where I'm coming from. So what are the learning objectives for Chapter 5? Well, after studying this chapter, the hope is that you can define circumstantial and direct evidence and explain how circumstantial evidence can be used. Understand when past criminal records and behaviors are admissible, and explain how and when character evidence may be admitted for or against a defendant. And I threw in kind of a chart that has some myths and facts about direct and circumstantial evidence. And while I'm not going to read them all, let's look at the first two. So a myth, a conviction cannot be based solely on circumstantial evidence. Well, that's not true. There's no rule that mandates which type of evidence are used to convict. And direct evidence is given more weight than circumstantial. Well, that's not true either, because the jury decides how much weight's going to be placed on each piece of evidence, and the credibility of witnesses has a lot to do with that. So if we go back to Chapter 4, we briefly discussed direct and circumstantial evidence, and we actually had some definitions. So direct evidence will be admissible if it was legally obtained and is not privileged. And as part of that, we know that direct evidence is personal knowledge from observation. So there's no need for inference or presumption. And again, it's admissible if it's obtained legally and it's not privileged. Well, on the other hand, circumstantial evidence is admitted at the discretion of the judge. And the judge considers whether the evidence is relevant and balances other factors such as the amount of time that it might take to introduce the evidence, confusion that may result from the evidence, and the possibility that the evidence may be unduly prejudicial. Now remember, circumstantial evidence indirectly proves a fact. And we've already heard that it's admissible if in fact it's relevant. And the judges determine the matters of law, as I just kind of talked about. But the jury, they determine the weight of the evidence and the credibility of the witnesses, and also the credibility of evidence. So in the featured case, Dr. Petit's testimony was in fact direct evidence of the home invasion. And you'll be able to correlate these after you read the case. But due to the fact that he was restrained in the basement, he couldn't provide direct evidence of the sexual assaults on his wife and daughter because he was in the other room. So it would be more of an inference, right? Which would be circumstantial evidence. So hopefully that kind of makes things easier to understand. Now remember, direct and or circumstantial evidence can be used to establish guilt, and the law does not place favor on either one. So the law doesn't favor direct evidence over circumstantial because the jury gets to decide. And when we talk about weight of evidence, U.S. courts, questions of law are decided by a judge, and questions of fact are decided by the jury, unless the trial, of course, is being heard by a judge without a jury. And stipulations and items judicially noticed are determined as a matter of law by the judge, and the jury decides all the disputed facts. Well, the jury, as the trier of facts, is given the duty to decide the effect and weight of each piece of evidence, like you look in this photo, like you see in the photograph before you in the O.J. Simpson trial, the gloves, the famous gloves. And this requires the jury to decide which testimony to believe if there is conflict between the testimonies of witnesses. If there is more than one possible interpretation of the facts, the jury has to decide which one is correct. And the jury also decides what inferences to draw from circumstantial evidence and which witnesses should be believed. And if more than one expert testifies about the same issue, the jurors have to decide which one is correct, which makes it very, very difficult when you look at the job of a jury. So when you look at the O.J. Simpson case, critical pieces of evidence in the O.J. Simpson trial were a pair of bloody gloves. And the left-handed glove was found outside the residence of Nicole Brown Simpson. And the right-handed glove was recovered from O.J. Simpson's estate. Now, circumstantially, what does that make you think? And I'll just kind of let you ponder that. And the O.J. case is a great case to do a case study on. It's a fantastic case to look at. So when direct evidence is introduced, again, the jury's main function is to decide the credibility of witnesses, and this usually revolves around two factors: the demeanor of witnesses and the likelihood that the witness said could have happened. And demeanor includes all type of, say, body language. And the jury also considers whether the witness was evasive or antagonistic. And common sense may be applied to the facts in order to decide if it was possible for the events in question to occur in the manner in which the witness described. And Facts disclosed during impeachment, such as personal bias or prior felony convictions, may also be considered, and jury instructions will usually explain all of this, and impeachment is covered a little bit more in Chapter 6. So again, in U.S. courts, questions of law are decided by the judge, and questions of fact are decided by the jury. And the jury, as the trier of fact, is given the duty to decide the effect and weight of each piece of evidence. And this requires that jury to decide, hey, which testimony do I believe? And if there's a conflict between the testimonies of witnesses. And if there is more than one possible interpretation of the facts, the jury gets to decide, or has to decide, which one is correct. So, some examples. How about credibility? So, circumstantial evidence is more difficult to evaluate. And again, the jury must decide the credibility of the witnesses. What inference should be drawn from the evidence, and the weight to be given to each piece of evidence. And there is frequently more than one inference that can be drawn from the facts, and sometimes the possible conclusions are quite contradictory. And also, individual jurors will have different ideas on the correct weight of various pieces of evidence. So the witness, some examples of credibility could be, hey, the witness refused to look at the prosecutor or the jury. So these are examples of credibility when we talk about being able to look at people's demeanor and body language. The witness gave evasive answers and refused to be pinned down on details, or the witness cooperated with one side but was kind of hostile when answering questions on the other. And the witness previously told the police, say, a totally different story. And all of that lends itself to what they call credibility. And credibility of witnesses can be found, remember, through things like demeanor. So we've kind of gone through that one. Well, what about circumstantial evidence and ability? Well, some crimes are committed in a manner that indicates that a suspect had some special skills or abilities that, let's say, the average person would not have. And the more unique the skill, the more or stronger the inference that the defendant is the person who committed the crime, if she or he has that skill. Now, obviously, the case must be based on more than just this one inference, but you know, the prosecutor hopes that the jury will conclude that the defendant is guilty if the defendant had the rare skill or ability that was required to commit that crime. So, as I said before, circumstantial evidence is more difficult to evaluate. And the jury gets to decide each one of these pieces. And when you look at some of these cases, specifically, let's say the O.J. Simpson case, there were just many different items of evidence to think about. And here's a link to an interesting article called 101 Items to Think About in the O.J. Simpson case. And if you have the time, kind of click on there. So, as I said, some crimes are committed in a manner that indicate that a suspect had some special skill or ability. And the more unique the skill, the stronger the inference that the jury can draw that the defendant is the person who committed that crime, if he or she has that specialized skill. So, for example, safe cracking is a skill that the average person doesn't have. So that could be one of those skills that we're talking about. And basic questions for a jury to think about when you're talking about special skills would be, hey, did the defendant have the skill? or the technical knowledge to commit the crime? Did the defendant have the means or the physical capabilities? Or did the defendant have the required mental capacity? And these are all questions for a jury when we're talking about circumstantial evidence as it relates to ability. And skills. We kind of mentioned that. The door was opened with a lockpick, or the burglar bypassed an elaborate alarm system in order to enter a building. So these are, skills or technical knowledge. Well, what about means? So the fact that a defendant had the means to accomplish the crime can also be used as circumstantial evidence if the average person would not have had access to the necessary equipment or location or something similar. So a simple example here would be, let's say, a person who worked at a company making explosives. They would have access to chemicals and such needed to make a bomb or something. And a person apprehended with a large quantity of small, clear plastic Ziploc baggies. They might have the means, if you will, to be selling drugs because they had access to those. So, kind of simplistic examples, but this covers what they call the means to accomplish the crime. And if you look on page 118, there'll be some more examples of means to accomplish the crime. Well, how about the physical capacity? And this can also be used to infer guilt in some cases. An obvious example is that the defendant's height, or is the defendant's height, if the physical facts show that only a very tall person could have committed the crime, or the ability to run very fast, or the fact that the defendant might be disabled and could not have run fast. So that can be used as well. And there are some examples on page 118 that talk about the physical capacity to commit a crime. So an example we can look at here, the burglar carried 50-pound bags out of the building. Well, that shows some physical capacity. And if your alleged suspect you're focusing in on or what have you can't do that, then you have the example here. Or how about the burglar entered the building through a window that would only open like a few inches. And what does that tell you? That the burglar probably had to be small in order to fit through that particular window. And again, some other examples are listed on page 118. Well, how about mental capacity? Well, mental capacity may also be relevant, and this is obvious if the defendant is pleading not guilty by reason of insanity or diminished capacity. Now, on the other hand, since adults are presumed to know things that are common knowledge, the defense may need to establish that the defendant has minimal mental capacity and therefore did not know that something was obvious to everyone else. And there's some examples on page 119 of mental capacity. So here's a couple of examples we can look at quickly. The defendant developed a very sophisticated plan to kill. So this is the heightened part of mental capacity. The defendant used a very complex chemical formula to manufacture drugs. So that would be another heightened one. Well, how about on the other spectrum? Well, the adult suspect acted like a 7-year-old. That might be to the other extreme. So less mental capacity, if you will. And circumstantial evidence as intent. Now, circumstantial evidence is frequently needed to establish intent. And this is doubly true in specific intent crimes. And the two most common approaches to establishing intent are modus operandi, which is MO for short, or motive. And definition used from these or used for these two terms, again, they kind of vary from state to state. So first, though, let's look at specific intent, and then we'll talk more about modus operandi and everything else. So when a crime consists of not merely in doing the act, but doing it with a specific intent, that intent is an essential element of the crime. And the statute may require a designated state of mind necessary to commit the crime. And you will generally find this intent in the code or statute, in the language. And it might say something like, every person with the intent to or for the purpose of, etc. So an example could be like burglary. Requires the specific intent to enter a structure, a dwelling, etc. With specific intent to commit a theft or any other felony. And again, it says it in the code. It actually says specific intent. Or other examples, again, would be every person with the intent to or for the purpose of. So back to modus operandi. Modus operandi literally means the method of operation. And its definition is a similar pattern of behavior or plan, often past crimes mirroring present crimes or offenses. And it is used to show an act is not accidental. So many criminals become creatures of habit and rather methodically commit the same crimes in the same way. And when this happens, the prosecutor can introduce evidence of the defendant's prior crimes that were substantially similar to the current one, and let the jury conclude that the defendant also committed the crime he or she is now charged with. Now, the fact that the defendant has been previously charged with violations of the same penal code section is not enough. There needs to be what they call great similarity in the method of committing the crime. And if there are many common features, the jury will be more likely to infer that the defendant also committed the crime for which he or she is now on trial. And the prosecutor may also be allowed to introduce evidence of very similar crimes committed by the defendant, even though the defendant was never charged with those offenses. And the judge has the discretion to admit or reject this type of circumstantial evidence. Well, motive. Well, this is a rational or emotional or practical reason for committing the act. So motive does not have to be proven by the prosecution unless it is included by definition in the crime. And even though it is not an element of the crime, it may be key to convincing the jury that the defendant is guilty. And this is particularly true when there is no direct evidence in a case. Now, depending on the facts of the case, possible motives could include hate or prejudice or revenge or retaliation or greed or lust or profit or economic need or love or mercy. And greed is a motive in many crimes. In a murder case, it usually means the criminal will profit financially from the death of the victim. And threats as well, statements or statement or promise in the past to commit an act like the present crime. So these are circumstantial evidence of intent. And again, kind of a review, because it's always good to go over this. The suspect avoided burglar alarms by entering through the roof, and he used a grappling hook to scale the wall and then chopped a hole in the roof. Well, this is an example of MO. The suspect entered the homes of single females at night through open windows, and the suspect stole their underwear, and before leaving tickled their feet to wake them up. Now, I know you're going to say ooh, or kind of maybe more like ew about that, but this was an actual case that was taking place in the Inland Empire, and the person was subsequently caught and prosecuted. But their MO, the way that they did it, and they did it several times, was to enter the homes of single females at night through open windows, and did take some underwear. But before the person left, he tickled their feet to kind of wake them up. So that's an example of an MO. And again, other examples could be greed, hatred, prejudice. These are all motives. So a husband was involved in an affair and wanted a divorce, but the divorce was never finalized because the couple could not agree on a property settlement, and the wife was found dead. That could be an example of motive. And again, hatred and prejudice are also motives. And motive may also be important if the defendant is claiming that a murder was committed in self-defense or in the heat of passion. And there's more examples of motive on page 121. So let's finish up with threats. We touched on it, but I want to make sure that we get to it. The fact that a defendant has threatened to commit the crime is circumstantial evidence that he or she committed it. And threats, again, may also be relevant in self-defense cases. And there's some examples of relevant threats to commit the crime on page 122. Well, now what about circumstantial evidence of guilt? So we've learned about, modus operandi and motive. Well, let's look at circumstantial evidence of guilt. What the suspect does following the crime may also be circumstantial evidence of guilt. Now, flight to avoid prosecution, attempts to hide evidence, possession of stolen property, sudden wealth, and attempts to silence witnesses are all commonly put into this category. And although the average juror probably considers the fact that the defendant has invoked the Fifth Amendment to be evidence of guilt, the U.S. Supreme Court has made it clear that the jury must not draw this conclusion. So stay with me. Invoking Miranda rights also comes under the same protection. So the court's reasoning here was that the constitutional rights would be meaningless if the jury would conclude that a person is guilty because he or she was using them. So let me kind of go through this again. Behavior after the commission of a crime is typically admissible. And we talked about the suspect that tried to avoid capture or conceal evidence or was in possession of stolen property. And then silence before or after the crime, however, cannot be admitted as evidence of guilt. And the example that I went over was the Fifth Amendment, where somebody in a trial decided, you know what, I don't want to incriminate myself, so I'm going to use the Fifth Amendment that I'm entitled to, and I'm not going to say anything. And the law is saying here, hey, the court says that you can't use the fact that this person is using the Fourth or the Fifth Amendment, in this case the Fifth Amendment, to conclude that they are guilty. So silence before or after the crime cannot be admitted as evidence of guilt. Now, this circumstantial evidence of guilt, this category we talked about, includes anything a suspect does to avoid conviction and serving a sentence. And the most common is, what do you think the most common category? And we talked about some of them. What's the most common one? Well, fleeing, that would be it. And this is the O.J. Simpson case with LAPD chasing the white Bronco, the famous fleeing. So the most common inference that jurors or people typically draw an inference from as far as guilt is concerned would be that of fleeing. And there's a case that I'd like to kind of go over, and there are some examples on page 123 of flight to avoid punishment. But the defendant here in Griffin versus California was accused of murder. And at trial, he did not take the stand to testify in his own defense. Because remember, if he does take the stand, he can be subject to cross-examination. So as a result of him not taking the stand, the prosecution commented on his silence, inferring to the jury that it was evidence of guilt. And Griffin was sentenced to death. But on appeal, the Supreme Court ruled that the prosecutor's comments were improper. Because you can't fault someone for utilizing those constitutional rights that they have, even though, in this case, the prosecutor, again, commented on his silence. So there's more. You could look at the case, but it's a pretty cool case, and it shows you that, hey, you know what? If you violate some of these constitutional issues that are listed in the 4th, the 5th, the 6th, the 8th, amendments, that the Supreme Court, if the case actually gets there, may overturn your case based on some of the things that you've done. So, applying the law to the right to remain silent, under what circumstances might make an innocent man remain silent and not take the stand? And I put this on there because there's the question always comes up, hey, why did O.J. Simpson choose not to testify? And if you were arrested and brought to trial, wouldn't you want to say something? So which is more likely, a guilty man avoiding testifying or an innocent man protecting some interest? And is there some other alternative that possibly is available? So we have flight, and now we have concealing evidence. Well, many fact patterns raise this type of inference. Some, such as arson to conceal theft or staging an auto accident to hide the fact that the victim has been murdered, involve detailed planning and can only be disproved by testimony from expert witnesses. Now, others, such as throwing a ski mask in a trash can while running from the scene of a robbery, can really be more easily established. And the defendant may try to hide evidence from the jury by asking witnesses to lie at trial. And this information can be used as circumstantial evidence of guilt. And the fact that the defendant tried to get a witness to alter testimony is admissible whether or not the witness agreed. So hiding or concealing evidence raises an inference of guilt, as does destroying evidence. So an example would be the suspect killed the victim and set the house on fire to hide the murder. The jury is allowed to draw an inference of guilt based on concealing evidence. Does that kind of make sense to everyone? And there's some more examples on page 124. Well, how about possessing stolen property? Well, in a theft case, the fact that the defendant was in possession of something taken during the theft is in fact circumstantial evidence that the defendant was the thief. And that kind of makes sense. And the inference is much stronger if the defendant had the property immediately after the theft. And that makes sense too. Now, receiving stolen property, called theft by possession in some states, rather than theft, may be a more appropriate charge when there is a substantial time lag, let's say, between the theft and the discovery that the defendant had the property. But nonetheless, someone that's in possession of property, the inference could be drawn that they were in fact the ones that entered and stole it in the first place, if we're going to use burglary as an example as the theft. And there are some other examples of possession of stolen property on page 125. And same holds true with sudden wealth. The fact the suspect suddenly had a lot of money soon after a property crime occurred can be used as circumstantial evidence. And this is also true if the defendant committed a violent crime such as murder. The prosecutor will ask the jury to infer that the money came from committing the crime. And again, there's some more examples of sudden wealth on page 125. Well, what about like character? And we've heard these things like, character witnesses. Or does character even matter in these cases? Well, it does. So character witnesses are used to try to convince the jury that a person did something consistent with his or her character. And most states use reputation as the evidence of character. And so, for example, if a person has the reputation for telling the truth, the jury may infer that the person is currently telling the truth. And this is circumstantial evidence, and the jury will get to decide how much weight to give to that character evidence. Now, the defendant's character in general, the prosecution is not allowed to attack the defendant's character unless the defendant has placed character at issue. And so basically, if the defense calls a character witness, then they have placed character at issue, and then the prosecution is allowed to discredit the person's character. So does that make sense to everyone? The prosecution is not allowed to attack a defendant's character unless the defendant has placed character at issue. So if the defense called character witnesses, the defendant's character has in fact been placed at what they call issue. And then the prosecution has two avenues to refute the defense's character witnesses: attack the credibility of the defense character witness, and or call character witnesses during rebuttal. So typically, the defense character witness who is called to testify about the defendant's good character is supposed to tell the jury what the defendant's reputation is in the community. And cross-examination that establishes that the character witness does not know what very many people think of the defendant reduces the impact of that testimony. So character in general. So character, what is it more definitively? Well, it's defined as a person's moral traits. And reputation is defined as what people believe to be a person's character to be. And again, there are some restrictions on admission. And usually character is only an issue, again, or at issue, if the defense or the defendant raises it as a defense. And it can be limited to whether a defendant did or did not commit a specific act. And character of the victim can be critical and is admissible as in all cases of self-defense. Now, the defense, again, the defendant's character has to be raised by the defense first, and cross-examination is really critical at this particular point. Now, in some trials, one of the defendant's specific character traits may be relevant. And since this evidence is relevant to a specific issue, it can be raised by either side. The prosecution can present this type of character witness during its case in chief and does not have to wait for the defense to call the first character witnesses. So this is where we're talking about specific character traits. And it's often raised relating to acts of violence or honesty. And it basically shows acting in conformity with that particular trait. And it can be raised again by the defense or the prosecution. And sometimes the character of the crime victim may be relevant. And this is most common in cases in which the defense is based on self-defense. If it can be shown that the victim was a violent person, it is much easier to convince the jury that the defendant acted in self-defense. Now, the inference would be even stronger if the victim's reputation included being like a bully. Now, the prosecution can use the reverse of this approach. For example, introducing testimony from a character witness showing that the victim had a reputation for being a non-violent person. That may convince the jurors that the defendant had no need to act in self-defense. So again, the character of the victim, and here's some examples of character. The defendant's character, the defendant or the defendant's pastor testifies that he or she is an outstanding member of the community. And under specific character traits, the defendant is charged with murder and claims self-defense. So the defense calls character witnesses who testify that, hey, he's a gentle person, he would never do this. And the character of the victim, the defendant is charged with murder and claims self-defense. Well, the defense calls character witnesses who testify that, you know what, the victim was really violent, and that's the reason that my client had to defend themselves. So applying the law, is character constant? Is a person's character a constant, or is it constant over time? Do you have the same character today as you had 10 years ago? Probably not. Is character in one area proof of behavior in another one? And is someone who commits adultery also more likely to kill or rape? And can we, or how can we prove character? Just food for thought. So what are some other acts of evidence? Well, other acts of evidence include a variety of situations in which prior actions of the defendant are relevant to the current case. And in these situations, prior acts can be used to infer that he or she committed the crime alleged in the current trial and in response to specific issues raised by the defense. Now, since introduction of this type of evidence is contrary to the normal rules, the judge must first decide whether the evidence is relevant and then whether the value of the evidence is outweighed by the potential prejudice against the defendant. And this is found under Federal Rules of Evidence 404, subsection 6, that talks about other acts or wrongs. So, the prosecution frequently seeks to admit past crimes committed by the defendant. And the general rule is that past crimes are not admissible, but they may get in if they show motive or opportunity or plan or preparation or knowledge or identity or absence of mistake. And this is usually a major issue of dispute between the defense and the prosecution at trial. So past acts of evidence, identity. Well, it's admitted to show past crimes are part of the pattern, the modus operandi. And it seeks to identify current crime with past acts. What about habit or custom? The fact that a defendant had a habit or custom or doing something can be used to infer that he or she did it when the current crime was committed. The victim's habits and customs can also be used to show that he or she was not voluntarily involved in criminal conduct. Habits and customs are easily confused with character traits. Habits and customs are more specific than character traits. A person's character may include being a liar or lying about someone's age. Can be a habit. So again, habit or custom, it's more specific than general character, and it's often used to show behavior. And evidence is admitted to show acted or did not act in conformity with a past behavior. So an example of some past acts for identity and habit or custom. A 72-year-old man is on trial for bank robbery, and he claims that the witness wrongly identified him as the robber. Well, the prosecution is allowed to show that robberies are rare, and the defendant has been arrested for 2 others. And habit or custom, well, the victim was an elderly man who was very frugal, and the prosecution asked the jury to infer that the large check written on the victim's account for an extravagant gift was not written by the victim because that wasn't his habit or his custom. And there's a couple other ones which we look at past acts of evidence, which would be, let's say, lack of accident, where the prosecution seeks to show past acts similar to the current crime, thus showing it wasn't an accident. Or prior false claims. Opposing sides usually use it to discredit a witness, and it has the greatest impact if the past act was in fact fraud or perjury. So there's a lot of information that we're going over. So examples again of past acts when we talk about lack of accident. The defendant was charged with carrying a concealed weapon and claimed he did not know the law covered this type of weapon he had, but the prosecutor was able to show that the defendant had previously been convicted for carrying the same model gun. So we can show that, you know what, hey, this wasn't an accident. And false claims. The defendant was charged with staging a traffic accident in order to defraud an insurance company. And he claimed it was an accident, but the prosecution introduced evidence that the defendant had been involved in 3 similar accidents and filed excessive claims in each. So again, examples of past acts. Well, what about offers to plead guilty? Now, if the jury knew that the defendant had tried to plea bargain, it would be likely to conclude that the defendant was guilty, if you kind of think about it. And although this is a very logical conclusion, there are strong policy reasons for denying the jury access to this information. Making offers to plead guilty admissible would interfere with nearly all attempts to plea bargain. The need to expedite court proceedings through the use of plea bargaining, is considered much more important than allowing the jury to know about the failed negotiation. So, for this reason, most states do not allow the introduction of any testimony about attempts to plea bargain or the fact that the defendant entered into a guilty plea, but for some reason was allowed to withdraw it. So the rationale, well, first of all, juries are not told, of plea bargain negotiations. And the rationale, parties need negotiations to be secret. If negotiations are not secret, many parties would kind of hesitate to negotiate. And again, when you talk about content of discussion may be admissible only in rare cases, if subsequently one party changes testimony, there could be some accusations of perjury. And if one side fails to follow through on terms of the plea bargain. So this is typically why they don't put that information out there. And then finally, we're getting close here, circumstantial evidence involving the victim. Now, the victim's injuries can provide circumstantial evidence that a crime occurred, and this usually requires testimony of an expert witness to explain that the injuries are inconsistent with the defense's theory in the case. For example, in a rape case in which the defendant claims the victim consented to having sex, a medical expert may testify that the type of genital bruises sustained by the victim rarely occur during consensual intercourse. So again, typically offered to prove an actual crime occurred. And parents frequently claim that an abused child was injured accidentally. An expert can testify that the x-rays show broken bones that were, let's say, at different stages of healing. And this is consistent with the battered child syndrome and indicates that there were multiple violent attacks on the child. And from this, it can be inferred that the latest injuries were in fact not accidental. And behavior of the victim can be used to infer that the crime occurred even though the victim did not conform to popular stereotypes of how a victim should behave. Because you know what? Not all victims are alike. And victims' reactions to crime and situations, they vary dramatically. And behavior can and should be observed before, during, and after a crime. So just remember that behavior of the victim, the fact that maybe they're not acting the way that a normal person would doesn't mean that they're in fact guilty, because all victims aren't alike. And again, the reaction to crime and situations, they do vary dramatically. So an example of circumstantial evidence as it relates to a victim. In a trial of a wife charged with the murder of her husband, the defense claims self-defense. The defense may introduce evidence that the husband had physically abused the wife on many occasions. And an expert witness can testify that battered women frequently become hypervigilant and therefore interpret small signs of aggression as indicators that a more serious attack is about to happen. And again, under circumstantial evidence and the victim kind of continuing here, victims of crime may suffer severe psychological impacts, and some of those possible symptoms or illnesses could be rape trauma syndrome or battered women syndrome or even post-traumatic stress disorder or syndrome. And then finally, and there are some examples or some more examples of circumstantial evidence involving a victim on page 135. So now finally, to kind of finish up, we'll talk about rape shield laws just briefly. Now, prior to the 1970s, it was a common defense tactic in a rape trial to dredge up the rape victim's prior sexual history. And the inference that the jury was encouraged to draw was that if an unmarried woman ever was sexually active, it was more than likely that she consented to sex with the defendant. Now, this approach was taken in stranger rape cases, as well as when a person alleged that a prior intimate relationship had in fact turned into a rape case. Now, legislature enacted laws referred to as the rape shield laws to stop this particular practice, and some are found in the evidence code and others are found in the penal code. And just as there are similarities in them, minor differences are also present. So for the purpose of our reading today in this textbook, the one in the Federal Rules of Evidence will be discussed. So we'll take a quick look at that and then we'll conclude. So if you look at Federal Rule 412, prohibited uses, the following evidence is not admissible in a civil or criminal proceeding involving alleged sexual misconduct. Number one, evidence offered to prove that any alleged victim engaged in sexual behavior, or two, evidence offered to prove a victim's sexual predisposition. And they have some exceptions under Section B in criminal cases. The court may admit the following evidence in a criminal case: evidence of specific instances of a victim's sexual behavior if offered to prove that someone other than the defendant was the source of that physical evidence, semen, injury, or other type of physical evidence. And B, evidence of specific instances of the victim's sexual behavior with respect to the person accused of the sexual misconduct if offered by the defendant to prove consent or if offered by the prosecutor. And C, evidence whose exclusion would violate the defendant's constitutional rights. So again, we've kind of we went through the rape shield laws, and we'll finish up. So we're right at about the 60-minute mark, so that's good. And that will conclude our lecture on Chapter 5, Direct and Circumstantial Evidence. And as always, if you have any questions, you can post them on the general discussion board. And if you don't want to do it there, you can send me an email. Don't forget to utilize the key terms at the front of the chapter and review those discussion questions, the review questions at the end of the chapter, and take the time if you really want to get into it and look at the examples that are listed throughout the textbook that are based on some of the facts and terms and things that we spoke about during this lecture. So with that being said, again, this will conclude our Chapter 5 lecture, and until next time.